And now it's time for another case law update. Today's case is a recent ruling from the 10th Circuit Court of Appeals called Atlantic Richfield Company versus NL Industries. This case revolves around an environmental contamination from an old mining site in Colorado that leaked sulfuric acid into a nearby river. The EPA stepped in back in the year 2000 to try to stabilize the situation, but the leaks persisted. Fast forward to 2011, and the EPA ordered Atlantic Richfield to build water treatment systems. Then, in 2021, Atlantic Richfield settled with the EPA, protecting the company from future liability in actions brought by the EPA or a third party in exchange for $400,000, and continued cleanup work. The following year, Atlantic Richfield sued NL Industries, a Texas-based lead smelting company, who was involved at the site, for contribution towards these years-long environmental cleanup costs. The U.S. District Court for the District of Colorado granted partial summary judgment in favor of NL Industries, finding that Atlantic Richfield's claims were time-barred by the limitations period for a cost recovery action outlined by CERCLA. However, on appeal, the 10th Circuit unanimously reversed this ruling. The core issue in the appeal was whether Atlantic Richfield's claim was one for contribution or cost recovery. This distinction is essential, as these two claims have different statutes of limitation under CERCLA, making this a make-or-break question for Atlantic Richfield's case. In reversing the lower court's ruling, the 10th Circuit ruled that Atlantic Richfield's claim was more appropriately characterized as an action for contribution rather than cost recovery. The ruling emphasized that even though the statutory provision listing contribution claims did not specifically include this type of settlement, the nature of the action and previous case law suggested that the 3-year limitations period for contribution actions was the closest fit, meaning Atlantic Richfield's claims could proceed. Under CERCLA, an action for a contribution refers to an effort to require a partially responsible party to pay their proportionate share of costs after an administratively or judicially approved settlement that resolves a party's liability to the federal government for an environmental response action. Here, once Atlantic Richfield settled with the EPA back in 2021, the statute allowed it to seek contribution for its expenses from those parties that had not joined in the settlement. Because the contribution statute of limitations applied, Atlantic Richfield had 3 years from the settlement date to file suit against any non-parties, which it did. In sum, Atlantic Richfield's claims were timely and valid, and they were entitled to try to recoup contribution costs from NL Industries. So why should you care? EPA actions and CERCLA cases are messy. There are a lot of moving parts, and everyone is pointing fingers at everyone else. But statutes of limitation provide a complete defense to some of these claims. So if your company finds itself involved in one of these matters, it's on you to make sure that you identify all responsible third parties and bring them in at the appropriate time so that your company isn't left holding the bag. That's all for today. I hope you found this helpful. I'd like to thank Miguel Otoro from our DFW office for his help on this update.